Hi, I'm Debbie Morais, and this is Legal Matters, the program that's been designed to address the critical and sometimes contentious issues that are facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and work life, from finance and family to workers' compensation and more. We first want to thank the sponsors of the program, which is the Bizarre Grasso Law Firm in East Providence, and we want to welcome David Bizarre.
Debbie.
Today, our topic is going to be personal injury. A look at how a case is handled, and also a discussion about some recent cases. It seems that every week there are more and more that are in the news, and I think we have a few that David will probably want to share with us. First, personal injury by the numbers, some relevant statistics that may help us understand why there's so many personal injury lawyers, as well as so many billboards and TV commercials, some disturbing, present company excluded, David. So the National Highway Traffic Safety Administration says 6 million car collisions in the U.S., one every 10 seconds, 3 million injuries every year from them, 125,000 collisions involving trucks, 50,000 serious injuries, 2,300 deaths occurring in motorcycle accidents, medical errors, about 100,000 fatalities every year, further data about prescribing and administering medication. Slips and falls account for 1 million hospital visits. Falls account for 8 million ER visits every year, more than 300,000 injuries and 1,000 deaths at construction sites. These numbers are just staggering. So whether it's car accidents and negligence, or the liability of product designers and manufacturers, whether it's an employer or retailer, entertainment venues, doctors, hospitals, the list goes on. And some people we know just complain, they go to the BB or they go to police and they get some quick reparation, and that's the end of it. But more often we know many will contact a lawyer to see how serious things are, and really if more issues have to be addressed, including some losses that need to have some compensation. So without really covering the many frivolous issues that come up and some unethical lawyers, again, present company excluded, let's just tackle the legitimate cases, and with little research, so many show up. So David, when people start talking about personal injury law, it's tort. What does that mean? What's civil law? Explain the basics, please.
Well, tort law is really just a word that defines civil wrongs. So if somebody's injured due to someone else's negligence or someone else's intentional act, we call that a tort. In personal injury cases, we're generally dealing with negligence. So that's what a tort is, that's what personal injury is. Personal injury cases can arise from, as you've described, a number of different perspectives, things that happen, auto accidents, slip and falls, negligence of a doctor, negligence of pharmacy and prescribing medications, as you mentioned. Personal injury is an injury to somebody's body that occurred as a result of someone else's negligence.
Okay. So we understand that many lawyers get very unflattering names, but on the positive side of it, the names that I also hear associated with lawyers who do personal injury law, some of the names are advocate, investigator, counselor. So if someone comes to you with a case, perhaps use one, how do you handle it? What's the start to finish, soup to nuts? How do you handle a case that's potentially personal injury?
Well, this is what we do primarily. Our practice has a lot of different areas of litigation. Personal injury is a litigation area. That just means that there's the potential for the case to end up in court. Doesn't mean it necessarily has to. In fact, most good cases get resolved. The issues that end up in court generally revolve around liability. So let me just break down what goes into a personal injury case. If someone is injured, there are a few aspects that you have to have. One of the first ones is, did someone else's negligence cause your injury? And what we're talking about there is, did someone do something that a reasonable person wouldn't have otherwise done that causes the injury? So the first thing that you have to have is the negligence, the wrong done to you by someone. So an easy example of that is you're stopped at a red light or a stop sign and someone isn't paying attention and rear-ends your car and you're injured. So you have the negligence. Then the next thing you look at is, what are the injuries that were caused as a result of that person's negligence? It's the causal relationship between the accident and what actually happened to you. And so damages are measured in pain and suffering, which is primarily what you're recovering in a lawsuit, plus what we call special damages. which are your actual out-of-pocket expenses for medical bills, prescriptions, those types of things, as well as lost wages.
Okay, so when someone comes to you with this kind of a situation, why wouldn't it be something as simple as, I have insurance, they have insurance, why would I go to see you? Why would someone who was in an accident go to see you? Because both people have insurance and it's covered, right?
Well, not necessarily. And so many things can go into what is covered, what isn't covered, what should be part of your damages, how do you measure damages. As a lawyer, these are things that I deal with all the time. So, for example, someone who's sitting at a red light and gets injured but doesn't have a serious injury, but they say a lot of times, well, I could have been killed. Well, you weren't, so that's not a measure of your damages. Whereas someone who's sitting at that red light has their neck turned slightly so that it causes more damage than if they were looking forward. And now, as a result of that, maybe they had some underlying condition that has totally incapacitated them, if not permanently for a significant length of time. The insurance companies oftentimes, remember, insurance companies are in business to make money, not to pay claims. No matter what they say, you're in good hands, this, that, or the other thing, like a good neighbor, it doesn't matter. What they really want to do is save as much money on that claim as they can. So they'll look at the accident, they might say, well, this isn't a significant impact case, your person had a pre-existing situation, so we're not going to pay them much, if anything. Well, frankly, that person who was sitting there that may have had some underlying condition that hadn't bothered them in years and being able to work, be productive, and do all of those things, now can't do anything. And that person is the last person who needed to have that impact cause the decline in their health and the inability to work any longer. And so an attorney can take that person through, get all the proper medical documentation and all the other evidence you would need to present at trial to be able to get that person a recovery and have that threat of that lawsuit be such that the insurance company should be willing to settle the case.
So that underlying issue, this accident could have triggered it. Is that negligent driver responsible for being that trigger?
Yes.
So that's where that comes down.
Yeah, absolutely. You take your victim, as we say, as you find them. So if in law school they talked about the eggshell skull theory. If somebody got tapped in the head, and most people wouldn't have any problem with that, and therefore wouldn't be injured and have no claim, that person who had that thin skull, the eggshell type skull, and now has a fractured skull, is going to be able to recover, even though most people wouldn't have had that same type of injury. It's you take the person as you find them.
So while we're talking about this particular car accident, would that lead you to say to anyone who has a rear end or an accident that no matter what they should go to see a lawyer, because a lawyer would just explore and determine and evaluate whether there was a problem? Is that true?
That is true. And there are so many different things that go into not only the evaluation and value of the case, but what coverage there is, because another aspect of personal injury cases is there enough insurance to cover the damages. And now we're delving into a whole new area. There's big differences in different states between, we do both Rhode Island and Massachusetts. Massachusetts, they call it no fault. And it really is just some really interesting rules. So just to lay out some of the big differences, in Rhode Island, if you're injured in an accident and your damages exceed the amount of the person's policy that caused the injury, their liability coverage, in Rhode Island, the minimum is $25,000, for example. So if you have $30,000 in medical bills and a fractured arm and you have some ongoing problems, and just for the sake of argument, let's say the fair value of that case is $100,000. So if the driver who hit you had the minimum of $25,000 and you have uninsured motorist coverage on your policy, which is, say, $100,000, you're entitled to get the difference in the value of your case from your own insurance company under the UM or uninsured motorist or underinsured motorist coverage. So if your case is worth $100 and you got $25, you can get another $75,000 from your policy. In Massachusetts, and let me make that example a little bit different. Let me say that you have the same $25,000 coverage on your policy. In Rhode Island, you would get the $25,000 from the tortfeasor, the person who caused the injury, and $25,000 from your policy, because your damages exceed the value of both together. In Massachusetts, they don't do that. They take the $25,000 in Massachusetts, the minimum is $20,000. So if it's the minimum policy, the $20,000 that the tortfeasor has, and if your policy is $20,000 for uninsured motorists, you don't get anything, even if your damages are worth $100,000, because they deduct the tortfeasor's policy from your policy. So why anybody in Massachusetts would have uninsured motorist coverage for $20,000, it only insures against someone who doesn't have any insurance,
okay,
because you're not getting anything under uninsured motorist coverage.
Okay, so again, talking about trigger, you think it's X dollars for the car and X dollars because you had to have something, MRI or an X-ray. But then you find out that in a week you end up with more pains and troubles than you originally would have said that you had because you didn't have it. Is that what another difference between why you would need to contact a lawyer because they would keep monitoring that, or is that not a factor?
Well, it can be. And there are certain things that insurance companies look at. If there's a big gap in treatment, the insurance company say, well, something else must have happened, we're not responsible,
which is true.
We don't have to pay. But a lot of times what happens is people want to see if things will recover or resolve on their own. So they might want to work through it and not go right away. And as an attorney, I'm an advocate for whatever the situation is for my client. So if you never had any problems before the accident, now you have neck pain or back pain or headaches or whatever it might be, and you've tried to let them resolve, you try to work through it. If you came to me, I would tell you, okay, let's go for a very short period of time, because I know what the insurance company is going to do. Go to your doctor, have them look at you, have them monitor you, have them tell you what to do. If they tell you to try to do some home remedies and some things that you might be able to stretch and do that at home, do it. Report back to the doctor if it's not working, and then maybe you have to be sent for physical therapy. But the key is, what the attorney is going to do is make sure that, first of all, we know what kind of coverage there is and that there's a protection for your damages. Secondly, that we've covered the liability issues. I've had cases where there have been motorists, for example, who cause an accident and take off. Now, do we go under our uninsured motorist coverage? Can we find it? Can we track down witnesses? So in one case recently, I was able to track down a witness who was mentioned in the police report, not as a witness, but as somebody else who had some involvement, but it wasn't clear. And I tracked that person down. I got a statement from that person that, yes, there was a third party responsible for the accident, and we got enough information to track down the owner of the vehicle so that we could pursue the person responsible. So there's a lot of things that you need to do early on, and that's why you should see an attorney early on.
Address that, because just what you said prompts the question. It makes sense that you should do it in a timely manner after the incident. What is timely? How do you describe that? Is that 1 day, 1 week?
Well, it depends.
How does that work?
On the situation,
okay.
And every situation is different. I have been contacted by folks, like 3 or 4 weeks later. Well, you know what? They were in the hospital for 2 weeks.
Okay.
Obviously, the first thing I always tell my clients is take care of yourself. Do whatever you need to do to make yourself better.
Okay.
We can always get to what we need to get to as long as we know. When they contact me, and I've been to the emergency room and I'm still not feeling better and it's a week later, well, at that point I really want them to come in or talk to them about the situation to make sure that they're taking care of themselves, number one, and number two, that they're not doing anything to hurt their claim.
Okay. And while you're talking about these things, these coverages and damages and the rest, let's talk about compensation, not necessarily theirs, but yours. So you have to take care of this client, and there's work involved. There's plenty to do, I'm sure. And it's also why they say that's why lawyers really want personal injury cases, because they make so much money. But obviously there's a lot of work to that. So address that issue. How does my insurance coverage or having you work on the case impact, how are the fees structured? Free?
So, no. Here's what happens. It's no out-of-pocket expense in most cases, if you will. So, and that's the concern of a lot of clients coming in. I don't have any money to pay you. Can you represent me? And of course the answer is yes, because what's really developed in the personal injury field, and which is something that's really leveled the playing field so that a person has an opportunity, if they need to get to court, to protect their rights and get the proper recovery they can, and that's the contingent fee. And the contingent fee is you only get paid as an attorney based on the recovery that the injured person gets, your client. So if for whatever reason I had to take a case all the way through trial and my client never recovered any money, I don't get paid anything. That's a risk I take. That's why it's important for attorneys to be upfront with their clients in analyzing a case and telling them what they think the case is worth and telling them whether or not they actually have a legitimate claim that they can follow up on. Because you talk about, people say there are frivolous claims, this, that, and the other thing. Most attorneys won't take a case unless it's a valid, legitimate case because they're getting paid on a contingency, and if they recover nothing, they're getting nothing.
Good to know. And considering Rhode Island and Mass and so many states have people traveling back and forth, how might this affect someone who was injured in another state in which other than where they are licensed? Does
Right.
the nature of that change? I mean, you talked about the difference between Rhode Island and Mass, but what if you were injured in one state versus, how does that impact?
So it's a very interesting question. We can write law school exam questions based on some of these things. So we have a couple of different things, but most of them are resolved on what you would call a conflict of laws analysis. So what does that mean? Well, if the accident happened in Massachusetts and you live in Rhode Island, the law of Massachusetts is going to be applied to the rules of tort and liability. In other words, the claim against the third party that caused the accident. In Massachusetts, they have a $2,500 threshold before you can recover pain and suffering. That's part of the no-fault law. That law is most likely going to apply. However, what law then applies to the uninsured motorist example that I gave to you? And my argument would be if it's a Rhode Island resident with a Rhode Island insurance contract, Rhode Island law now applies because it's based on contract law, not tort law, and it's your insurance contract that would apply, and that's the policy that would take effect.
Good to know. I'm glad I asked that.
And interesting, too, isn't it?
It is. So when there's an accident, you can take pictures, and that's part of documentation. I know you always say on every show, whenever you have an opportunity, document, document, document. So not talking about car accidents, but something that might be considered personal injury, although I wouldn't have imagined it. What happens? Can you sue a restaurant, for example, for food poisoning? You can't take a picture of, I think I was poisoned because they didn't store the food or prepare the food properly. How does that play out, David?
So let me answer that question, but just go back to the picture thing for 1 second, because I'm sort of the older dinosaur kind of generation, and I don't realize that my phone is also a camera sometimes. So one time, I was involved in an accident, and I was pulling out of a school to take a left, and all of a sudden, I got hit, and I'm getting out of the car, and I'm a little bit stunned. And what happened, and I didn't even remember, really, I must have banged my head and not exactly understood what happened. A driver, or another person came up to me and said, "Do you know what happened?" And I said, "I'm trying to figure that out." So he said, "Well, I stopped to let you out, and so you started to go, and the car behind me pulled around me over the double yellow line and hit you as you were turning." And I said, "Oh, I knew I was okay and going, I just never saw that car and never knew where it came from." So it was actually a younger person. So he said, "You should take a picture, because if you look right now where the cars are, where they came to rest, that car's on the other side of the double yellow line, and your car's already past the double yellow line where the two cars collided, so take the picture." So I took the picture with my phone. And it was really important that I did, because the insurance company's position initially was it was my fault because I pulled out of the driveway in front of the other car that had the right-of-way. And I said, "Yeah, you know what, and that's what I thought when I banged my head and everything, but then when I realized what happened, I'm going to send you a picture and take a look." The car stopped for me to go. Your client went around, your insured, went around the stopped car over the double yellow line. I had no chance to see him, and it was his fault because you shouldn't pass a stopped car and certainly not over a double yellow line. So they came back and said, "Yep, that picture shows it, you're right, and your car's going to get paid for by us." So pictures are really very important, especially at the scene of the accident. Now to go to your second question, food poisoning. We've handled a number of those different types of cases and some very interesting and different situations. Food negligence. It's something that is very real and has to be proven by the evidence. So how do you prove that the injury I got, the illness, the nausea, the diarrhea, the sickness that ruined my vacation or whatever else it did, is related to somebody's negligence in food preparation? So the difficulty with those cases is if it's just you and you ate in a number of different places, proving where it happened. But I've had cases where many people have been struck ill and had illness from the same restaurant. So now you have a whole thing of evidence. The medical records for my client will show that they definitely poisoned by food. I can prove that. Now I can prove where it was because my client ate at this particular restaurant, and there's a whole slew of other people who ate there that day that were also sick.
Now, would you have to go and find their restaurant receipts and who was there so that you could ask them, or how would you do it?
Well, that would be one way to do it.
Okay.
If that was the only way to do it. In this particular case, there were so many people who got sick that it was well known. If you remember back, there was a case with pastry and the filling in Rhode Island. A bakery had sent out some bad pastry. A lot of people got very sick and ill. So that's the Department of Health, when they step in, that really makes your case a lot simpler to prove. Other types of cases that have been easy to prove and sort of disgusting was I had a client who went to a fast food restaurant, we won't say which one because it doesn't really matter, and was eating a hamburger and felt a crunch. And there was no crunchy materials in that particular hamburger as they thought it would have been prepared, and opened it up, and lo and behold, there was half of a cockroach left in the hamburger. Now, they became ill, not like a food poisoning case, but it was really agonizing for this particular person.
Sure.
And what made it more agonizing was that there was only half a cockroach left, and not the full cockroach. Right? Cockroacha.
That's terrible. But if someone gets sick, they get nauseous, is that sue-worthy, David, or you've had some discomfort? How do you monetize that, or do you not bother?
Not really. I mean, if you were just had one day's worth of illness and recovered perfectly fine, most attorneys aren't going to find that there's enough damages to make it worthwhile to take that case. If you want to write to the restaurant and stuff, I've had clients do that and report back to me, yeah, you know what they did? They gave me a gift certificate, or they did something to make up for it. To make
amends. But in that case, do they really need a lawyer, or do they just go directly to that offender and handle it themselves?
This is what I would do. I would contact a lawyer.
Okay.
I would ask the lawyer what his or her opinion is. The lawyer can evaluate the case. If it's a one-day kind of, I'm fine illness thing, they might tell you, oh, it's not worth hiring me to do it, but this is what you should do, and get some advice on what you need to do.
Okay. A couple of other kinds of cases, but this is about consumers as well as employer-employee thing, which I guess crosses over into workers' comp, and I don't want to go
delve too deep.
Well, findlaw.com has no shortage of very recent cases that are sort of amusing, but not really. Most people like to go to those big box stores, save money, it's fast, it's easy, and one-stop shopping. It's not so funny or not so much fun if somewhere those large stacked boxes come crashing down on your head. A, you're the consumer, B, you're the employee. So, how does that play out if you're either one? Let's go with the consumer first. That might be the easiest to tackle. I don't know.
Well, the consumer does become a personal injury case.
Yes.
And I've had many of these kinds of cases, negligent display of merchandise. If you stack them too high, something falls on you, then clearly there can be liability for that, because if it's not something that's reasonable and you didn't have to do it that way, it's negligent. So I had cases against supermarkets, and if you notice now, they put the grapes in bags. Before I had this particular kind of case, they just put them in big bins and you bag them yourself, because they wanted you to try them and see how good they were and maybe buy more than you might otherwise, and they end up on the floor. Grapes always end up on the floor, and people slip and fall. So it's hard to win those kinds of cases based on the grape on the floor in and of itself. My argument was, you're negligent on how you display them, because you know they're going to end up on the floor. Maybe not this particular grape, but grapes in general, so we were able to win that case. I had a case against, we'll call it the largest retailer in the world, and they fight everything, and we were in federal court, and we ended up mediating this case. And it was, again, a display situation. Something fell and injured my client. So we're in mediation, and we're getting very close to settling this case. It was worth a significant amount of money, and we're now only $10,000 apart. The mediator said to the insurance company's attorney, well, actually they're sort of self-insured. They own their own insurance company. Call the adjuster and just tell them I'm saying split the difference, $5,000 more, you take $5,000 less. We said fine. So the attorney goes out and calls the adjuster in Bentonville, Arkansas, and said, we can settle this case, you just need to come up 5 and they'll come down 5. And the adjuster said no. So the magistrate in federal court said, well, they have jets. That's fine, I can't force him to do anything. Tell him to jump on one of the corporate jets and be up here tomorrow and just explain to me why we can't split the difference here. And he came back and he said, you're not going to believe it. He said he'll pay the extra $5,000. So we got it settled. So the long and short, that was the long part of your short question, is yes, the display information situation can create negligence and there can be claims against that. If you're the employee of the company, your claim becomes a workers' compensation claim rather than a liability claim, because you can only recover for your injuries under the workers' compensation statute unless somehow you opted out of workers' comp.
The person who's the consumer, he's not supposed to be rattling around and taking down those huge boxes. Isn't he supposed to call someone? If he takes it on his own, does that mean the onus is now partly on him and not so much on the employer? Sometimes we've talked about maybe having some shared responsibility.
Contributory negligence.
Okay.
Okay.
Does that apply?
So it can. So if the store has those ladders there and a person climbs up the ladder and tries to take something down and gets hurt, perhaps they shouldn't have climbed up the ladder. Perhaps there was a sign that says employees only. Perhaps there wasn't. Depending on all of those perhapses, defines whether or not there is some contributory negligence. And in Rhode Island, we have a pure comparative negligence situation. So you compare the negligence. If the person who caused the injury was 50% negligent and you as the injured person contributed or was comparatively 50% negligent, you only get 50% of your damages. If they were 70% negligent and you were 30% negligent, you get 70% of your damages. If it's the reverse, where you're 70% negligent and they're only 30% negligent, you get 30% of your damage. As opposed to other states, let's say Massachusetts, they have not pure comparative, but contributory negligence. So if you're more than 50% negligent in Massachusetts, you don't recover anything.
Good to know. And if you are the employee and your employer has done his best and tried to stack those boxes and have someone look at them every day and has his employees take a handbook or a video of how to pick up heavy things and has done what he could in his mind to keep you safe, but you wrenched your back because you just happened to move the wrong way, is that a part of that contributory issue, or is he off the hook?
Does not matter in
Keep
workers'
the employer
comp.
off the hook.
Right. In workers' comp, there is no need to prove negligence, and there's no defense for contributory or comparative negligence.
Okay. And this is also a part of a workers' comp issue, but can someone who is working actually be PTSD if they weren't a vet?
Post-traumatic stress
They had
disorder.
another kind of stress.
Yeah. You can get PTSD from negligent situations, workers' comp aside. For one quick example, I had a case once where a woman was in a car with her husband. Something came through and knocked his head off. And clearly there was some traumatic stress from that for that woman that haunted her for the rest of her life.
We have so many of these, more of these. I think that maybe the next session we should discuss more of these worker compensation issues. We hope that this has been helpful to you. Obviously, we hope that you never suffer from personal injury or never have to deal with these things, but we hope that you're better tuned in. Stay tuned to Legal Matters as our discussions will continue.